CPL 270.30. After the trial of an indictment, the court must either 1. With consent of people and defendant, discharge alternate jurors, or direct alternate jurors not discuss the case and must further direct they be kept separate and apart from regular jurors. 22. 270.35. Before discharging a juror in a criminal case, the court 1. Must allow the people and defendant an opportunity to be heard. Must place on the record the facts and reasons for its determination that such juror is ill, incapacitated, or unavailable for continued services. 23. When two or more indictments against the same defendant or defendants charge different offenses of a kind that are joinable in a single indictment, the court may, upon application of the people or defendant, order that indictments be consolidated and treated as a single indictment for trial purposes. The court cannot do this sua sponte, so no consolidation sua sponte. 200.20 subdivisions 3 and 4. In any case where offenses are joinable but based on different criminal transactions and the joinability rests solely upon the fact that such offenses are the same or similar in law, the court, in interest of justice and good cause shown, may, upon application of defendant or people, order that the offenses be tried separately. Good cause shall include but not be limited to situations where there is 1. Substantially more proof on one, and there is a substantial likelihood jury would be unable to consider separately the proof as it relates to each offense. 2. A convincing showing that a defendant has both important testimony to give concerning one count and a genuine need to refrain from testifying on the other, which satisfies court that risk of prejudice is substantial. Good cause under this paragraph may be established in writing or upon oral representation of counsel on the record. Any written or oral representation may be based upon information and belief, provided the sources of such information and the grounds of such a belief are set forth. Upon the request of counsel, any written or recorded showing concerning defendant's genuine need to refrain from testifying shall be ex parte and in camera. The in camera showing shall be sealed, but a court for good cause may order unsealing. Any statements made by counsel in the course of an application may not be offered against defendant in any criminal action for impeachment purposes or otherwise. A court's determination pursuant to subdivision 4, which is one I didn't read, so let's go back to sub 4. When two or more indictments against same defendant charge different offenses of a kind that are joinable pursuant to sub 2, the court may, upon application of either people and defendant, order that such indictments be consolidated and treated as a single indictment for trial purposes. In such indictments, in addition to charging offenses which are so joinable, charge other offenses. If such indictments charge offenses that are joinable and others that are not, they may nevertheless be consolidated for the limited purposes of trying the joinable offenses. In such case, the indictments remain in existence with respect to any non-joinable offenses and may be prosecuted accordingly. Nothing herein precludes the consolidation of an indictment with an SCI. 5. Okay, so that now we can go to a court's determination of an application for consolidation pursuant to sub 4, which is what I just read, is discretionary, except that where the defendant seeks consolidation with respect to offenses which are of a kind that are joinable in a single indictment by reason of being based upon the same act or transaction, the court must order consolidation unless good cause to the contrary be shown. So again, it's a soft must. Okay, effective October 1st, 2018, where an indictment charges at least one offense against a defendant who was under the age of 17 or commencing 10/1/19 under the age of 18 at the time of the commission of the crime and who did not lack criminal responsibility for such crime by reason of infancy, the indictment may, in addition, charge in separate counts one or more offenses that the person is not criminally responsible for. If the offense that they are responsible for are based upon the same acts or criminal transaction, or the offenses are of such nature that proof of the first would be material and admissible as evidence in chief upon a trial of the second, or proof of the second would be material and admissible as evidence in chief upon the trial of the first. So, the difference is when you're talking about criminal responsibility by infancy, the only two ways is same acts or transaction or proof material and admissible as evidence in chief. Okay, so there's 4 for the regular ones. It's joinable. Generally, 2 offenses are joinable when same act or criminal transaction, different criminal transactions, but the proof is material and admissible as evidence in chief. And then 3 is based on different transactions and not joinable pursuant to B. The offenses are defined by same or similar statutory provisions and consequently are the same or similar in law. Or D, though not joinable with the A, B, and C, each offense is so joinable with the third offense contained in the indictment. In such case, each of the 3 offenses may be properly joined not only with each other, but each of the other 2, but also with any further offense joinable with either of the other 2, and the chain of joinder may be extended accordingly. 270.20, Trial Jury. Challenge for cause of an individual juror. 1. A challenge for cause is an objection to a prospective juror and may be made only on the ground that 1. Lacks qualifications required by judiciary law. 2. State of mind likely to preclude him from rendering an impartial verdict. 3. Related within 6th degree by marriage or blood to defendant, complainant, prospective witness, counsel for defendant, the DA, or that he was a party adverse to any such person in a civil action, or that he is complained against or been accused by any such person in a criminal action, or that he bears some other relationship to any such person of such nature that is likely to preclude him from rendering an impartial verdict, or 4. He was a witness at the preliminary examination, the grand jury, or is to be a witness at trial, or 5. He served on the grand jury which found the indictment an issue, or served on a trial jury in a prior civil or criminal action involving the same incident charged in the indictment, or 6. The crime is punishable by death and he has opinions in favor or against such punishment. Okay, so again, those 6 are lack qualifications required by judiciary law, state of mind, relationships, witness, previous grand jury service for same indictment, and death penalty issues. 2. All issues of fact or law arising on the challenge must be tried and determined by the court. If the challenge is allowed, the court must exclude the person challenged from service. Now, here we go to the erroneous rulings part. An erroneous ruling by the court allowing a challenge for cause by people does not constitute reversible error unless the people have exhausted their peremptory challenges at the time or exhaust them before the selection of the jury is complete. An erroneous ruling by the court denying a challenge for cause by the defendant does not constitute reversible error unless the defendant has exhausted his peremptory challenges at the time, or if he has not, he peremptorily challenged such prospective juror and then he runs out of challenges before the selection is complete. So the reversible error for the DA is that they erroneously allow someone to be challenged that shouldn't have been allowed. And reversible error for the defendant is when they deny a challenge for cause. 270.25 trial jury peremptory challenge of an individual trial juror. So it's when no reason may be given, 20 for an A felony and 2 for each alternate, 15 for C or B felony and 2 for each alternate, and then every other case, which is D, E, or misdemeanor, 10 for the regulars and 2 for each alternate. In the case where there's multiple defendants, a peremptory challenge by one or more defendants must be allowed if a majority join in the challenge. Otherwise, it must be disallowed. And that, I guess, is interpreted to mean, because I was told this today, that when there's two defendants and one wants to challenge someone and one doesn't, then they have to disallow it. $270.35 trial jury discharge of juror replacement by alternate. 1. If at any time after a jury's been sworn and before rendition of verdict, a juror is unable to continue by serving by reason of illness or incapacity or other reason unavailable, the court finds from facts unknown at the time of the selection that the juror is grossly unqualified or is engaged in misconduct of a substantial nature but not warranting a mistrial, the court must discharge him. If an alternate juror is available, the court must order that the discharged juror be replaced by the alternate juror whose name was first drawn and called, provided, however, that if the deliberation started, the defendant must consent. The consent must be in writing and be signed by defendant in person in open court in front of the judge. If the discharged juror was the foreperson, the court shall designate as the new foreperson the juror whose name was second drawn and called. So the alternate does not just pop into the foreperson seat. That's what it says in the book. If no alternate juror is available, court must declare a mistrial pursuant to sub 3 of 280.10. A court's discretion has discretion to discharge a juror who repeatedly fails to appear in court in a timely fashion. The court shall let the parties be heard before discharging a juror. If the court discharges a juror pursuant to this subdivision, it shall place on the record the facts and reasons for its determination that the juror is ill, incapacitated, or unavailable for continued service. So that's got to be on the record. So the consent to replace the juror has to be in writing in open court by a defendant, but when the juror is discharged, the court has to state on the record why. $270.40 trial jury preliminary instructions by court. After the jury is sworn and before the people open, the court must instruct jury concerning its basic function, duties, and conduct. It must include admonitions that jurors not converse or with anyone amongst themselves or otherwise upon any subject connected with the trial. They can't talk about it with their family. They can't read about it in the media. They can't visit or view the premises where it was allegedly committed. And prior to discharge, they may not request, accept, agree to accept, or discuss with any person any payment or benefit in consideration for supplying information concerning the trial, and that they must promptly report to the judge any incident within their knowledge involving an attempt by any person improperly to influence any member of the jury. 270.45. During the period extending from the time the jurors are sworn to the time they retire to deliberate, the court may, in its discretion, permit them to separate during recesses or direct they be continuously kept together during periods under supervision of an appropriate public servant or servants. In the latter case, the servants must not speak to or communicate with the juror concerning any subjects connected with the trial, nor permit another person to do so, and must return the jury to the courtroom at the next designated trial session. So when there's a view